what can be patented? Patents can be granted only for an invention that pertains to a field of technology. So, the field of technology is very important, because if there is no field of technology, then a patent cannot be granted. Patents are technology specific, in the sense that patents can only be granted for technological inventions. Though the Patents Act do not describe inventions as technological inventions, it is understood that inventions that are made in a particular field of technology. In fact, the Patent Office is designed in a way in which they have group of examiners who have skills in a particular technology, analyzing and examining patent applications that come from different fields. The International Patent Classification, which is a code that is used for classifying patents, is again a technology based classification. So, if you file a patent application in biotechnology, then it will be examined by a group of examiners, whereas if you file a patent application for a pharmaceutical drug, it would be examined by a different set of examiners. Patent law is technology specific, and you have not only experts within the patent office, but also the attorneys who draft these patents would also have some amount of domain knowledge pertaining to their particular field. Inventions under the Act can be granted for a new product or a process. The invention should involve an inventive step, and it should also be capable of industrial application. Now, this is the definition of invention, which is mentioned in section 2(1)(j) of the Patents Act. So, from this we can understand three things. For anything to be an invention, the fact that something has to be new is referred to in patent law as the novelty requirement. Something has to be novel, or the novelty requirement. The invention should also involve an inventive step. Now, we will explain inventive step in some detail soon, and the invention should be capable of industrial application. This is largely called the utility requirement. Inventive step is also called the non-obviousness requirement. The fact that the invention should not be obvious to a person skilled in the art. We will be looking at these definitions in some detail soon. Now, what is important here is that invention has three requirements: novelty, inventive step, and utility. But for something to be an invention and for something to be captured as a patent, the product or the invention should manifest itself in the form of a product or a process. So, that is why you have the new product or a process mentioned together. So, if the invention cannot be envisaged as a product or a process, then a patent cannot be granted. For instance, somebody envisages an invention as an idea, an abstract idea, no product comes out of it, no process of manufacturing or working it is described, it just is an idea. For instance, somebody comes up with the bright idea of making a cycle that you could pedal to the moon. Now, that remains an abstract concept. It is not something that can be worked out, it is not something that there can be a product on it, but it is just an idea that you could cycle your way to the moon. So, abstract ideas cannot be patented. Patent should manifest itself on either a product or a process. Invention can also cover improvements to existing inventions. So, you have inventions which are new, involve an inventive step, and are capable of commercial industrial application. The same yardstick can also be applied to improvements to existing inventions, provided those improvements are new, they involve an inventive step, and they are capable of industrial application.